Originally, the Benami Transaction Prohibition Act was enacted in 1988. The tenor of the provisions of that act, it had only 9 sections, was that any person who wishes to acquire an asset or a property must do it in his own name with his money. If he acquires it in the name of somebody else, then it is deemed to be a Benami property. Now, even though 2 judgments of the Supreme Court came as to which is a Benami property, which is not a Benami property, from 1988 till today, 2016, this law has not been put into effect. And the reason why this law was not given effect was that the law provided for 2 significant provisions as to the fact that if there is a Benami property, Benami transactions are prohibited. The state will have the power to acquire the Benami property. And further that, the person who enters into this Benami transaction is liable to be prosecuted. There was nothing else mentioned in the act. Now, when this act went to the Law Ministry thereafter, there was no machinery provided for how the acquisition is to take place. What are going to be the terms of the acquisition? It was not provided for. At the time when this law was framed, it was thought that everything else would take place by virtue of rules. And probably the Law Ministry thought, and rightly, that this would be a case of excessive delegation. There are some vital provisions in every law which have to be provided in the legislation itself. Some non-operational provisions could be operationalized through the rules itself. So the Law Ministry said the rules can't be framed. This act had to be operationalized through rules, and the rules were never framed. Thereafter, an effort to bring in this particular legislation subsequently, and after it was brought in, this legislation, it was then redrafted in 2011 by the UPA government in form of amendment to the 1988 bill. And the reason why we want to amend the 88 bill, so the original bill is 9 sections, but a large number of sections were added, and one proposal was that it should be repealed and a new bill should come in. But then if we brought in a new bill, properties acquired Benami between the period of 1988 onwards would have all gone scot-free. So it was considered necessary that the old law be allowed to remain and the new amendments be inserted into the old law itself. Now that bill lapsed with the lapsing of the Lok Sabha, even though it was referred to a standing committee and a report did come. In 2015, a fresh amendment bill was introduced by us. The original bill is 9 sections, the amendment is 71 sections. And the reason for incorporating the amendments in the bill is again the same, that we want the bill to be operational from 1988 onwards. And a large number of amendments have been introduced. This bill has been referred to the standing committee. The standing committee has given a certain set of recommendations, and the most important amongst them was that what are the exceptions to the Benami principle. One exception which the law provided for was properties held within an undivided Hindu family. That is, property may be in the name of the Karta, but the beneficiaries may be other co-parsoners. The second amendment was in the event of a trust, a trustee can hold the property as a fiduciary of the principal trust. So those would be exempted. Now there were certain categories of amendments which members of the standing committee itself suggested, that there are a large number of properties, particularly in the Union Territory and elsewhere, where transactions take place on a power of attorney and an agreement to sell, people are put into possession, and by virtue of the provisions of Section 53 capital A of the Transfer of Property Act, the possession is protected. But the property continues to be in the name of the original owner. Now, will those be treated as Benami? And therefore, members suggested that a further amendment be incorporated that properties which are already under some form of an arrangement of this kind should really be brought in as far as this legislation is concerned. We considered it appropriate, and that key amendment has been accepted by the government, and therefore those amendments have also been circulated as far as we are concerned. So the principal object behind this bill is that a lot of people who have unaccounted money invest and buy immovable property in the name of some other person, a non-existent person, a fictitious person, or a Benami person. And therefore, these transactions are to be discouraged. From the very beginning, the effort of the government has been, as far as assets illegally held abroad are concerned, they should be squeezed. The use of cash beyond a certain limit should be discouraged. And unaccounted money must make way, and therefore the color of transaction of money itself must change. And therefore this is an important step in that direction itself. It's predominantly an anti-black money measure, that any transaction which is Benami is illegal and is liable to be, the property is liable to be confiscated, it will vest in the state, and the entrant of the Benami transaction is liable to be prosecuted. With these few opening remarks, I commend this bill for discussion and finally acceptance of the Honorable House.
जिन्होंने देश के बंटवारे को मजहब के नाम पर कबूल किया वो सेक्युलर है, जिन्होंने उस वक्त मुखालफत की वो कम्युनल है।